greater specificity of what the constituents of the material that they're introducing to the site would be hard to perform that analysis.
When you were in the Highlands Commission, did you, council, did you review or consider the wellhead protection ordinance adopted by Chester Township? Was that part of your purview?
No, we developed the standards relative to how the wellhead protection program would be incorporated into the regional master plan. At the point in time that I left the council, we hadn't gotten into conformity yet.
So you wouldn't know whether that was one of the more stringent wellhead protection ordinances?
No, I'm not familiar with the Chester ordinance at all.
Would you be aware that this would not be a prohibited use under that ordinance? Or under any wellhead protection ordinance in the state?
If you're saying asphalt use alone, I would agree with that. It is not the asphalt use alone that's prohibited, and certainly not wellhead protection area alone that prohibits asphalt from within this area. It is primarily the prime recharge area in the carbonate rock, which results in the prohibited use. There's also wellhead provisions, but this site isn't within the Tier 2 wellhead protection area. So in this particular case, wellhead protection is not relevant in terms of prohibiting asphalt manufacturing facilities from this particular location.
So wellhead protection isn't relevant, but it's still your testimony that there's a significant risk of this exposure.
Yeah, because my concern with exposure was not specific to potable water supply intakes. It was more the individual well.
Any other questions?
Any further questions?
Mr. Balzano has a family commitment which he's already late to. Can he be excused now that there are no more questions?
Is he coming back?
No.
No.
Without objection, you can be excused.
I'm sorry?
Without objection, you can be excused.
Well, thank you very much. Thank you, everyone.
Paul, do you have any kind of questions?
Yes, there have been a number of questions through the first three hearings on the issue of cars, and that issue continued tonight. I brought with me tonight one of my partners in my business who helped review the geotechnical report that was submitted to the board and provide commentary. His name is James Serpico. So I wanted to have Jim present his review of the report and his conclusions on the report that was submitted regarding the geotechnical report that was submitted by the applicant, and be available to answer any questions from board members as well as the public. So without further ado, I'm going to have Jim come up here and sit down and do that.
Okay.
Mr. Chairman, if I may ask, my name is Lisa Nash.
At this point, I'm not asking any questions.
Can you please put your name and address on the record, which you've never
I
done?
did last night.
What was it?
Lisa Nash, 2 Sundance Way, and I did give it.
And which town?
Oh,
Thank you very much.
I just would like to say, I think it's very unfair that we do, as a public, have a right to cross-examine a witness that was presented.
That wasn't a question.
Give us the benefit. State your name for the record first.
I already gave the card, but it's James, James J. Serpico Jr.
All right. Give us the benefit of your professional background, please.
He was.
Oh, thank you.
From school.
Yes.
Bachelor of Science degree, Lafayette College. From there, Master's of Science degree from Stanford University, majoring and focusing on geotechnical and structures. From there, work product, different, mostly for geotechnical engineering firms, and had my own firm. Last 16 years, I've been the director of geotechnical services for Maser Consulting.
All right. Have you testified before boards before?
That's correct. I'm also a certified municipal engineer.
All right. Just give us a basic idea how many times you've been before boards to testify in your expertise.
Well over 100.
All right. Any questions?
Nope.
All right.
Without objection, he's qualified as the expert.
Thank you. Go ahead.
Thank you. I guess I've been asked just to get used to the microphone. I've been asked to go over what happened on this application and the way it comes to me. For the last 10 plus years, I believe almost all the applications in this ordinance have been coming across my desk in one way or the other. So it starts out reviewing what was submitted with the applicant. I did a cursory review of it. We've been doing this for so long in this town that we actually have gotten more stringent than the minimum set forth in the ordinance. So we asked and they complied for additional test probes, primarily in the area of the proposed detention pond, as well as a few other areas where there were storage areas proposed. We felt that they should at least do some, in this case, test probes under. The original report I reviewed was dated September 9th, 2011. And by September 13th, I'd gotten the addendum report, which had the extra probes. Basically, when we review it, you have a table, the Lopatcong ordinance has a table that says, based on your projected development in the form of structures, infrastructure improvements, and basins, there's certain minimums. That is the first test we do. So we estimated the square footage of foundations, which is around 10,000 or less. We then estimated the amount of infrastructure area, which is less than 5,000 square yards, and there's one basin. And then we then checked off how many test pits, how many borings, how many probes did they do in each of those areas, and did they meet it? And they did. They did 14 test pits. They did 3 test borings. I understand that Paul testified to more, but there was a boring 1 and a 1A. That's actually, it was a continuation of each boring. So there's 3 borings done. There was a total of 20 probes done, 12 in the original, 8 in the follow-up addendum. And the borings, there's a checklist in the ordinance. Did they meet? Did they meet? They have to do so many borings, at least 20 foot of rock, or to a maximum of 50 feet. And they've met that criteria. And from that point on, we just look for the generalities. This site, it's definitely the carbonate area. It's dolomitic, meaning it's less susceptible to water erosion. It's not carbonate. That's worse. Still has, they did find some fissures, not as many as you would think. It is overlaying the natural decomposing of the dolomite, forms a clay soil, and we found the clay across the whole site, 1 to 12 feet thick. The only area that didn't exist is in the area where the existing road is. It looks like it's been cut, so they probably took the overburden through the years off. There is pinnacles of rock, which is expected. We've run across it in the town before. And then we compared what kind of structures they have. And usually this is all done, and then usually I get the call after if it does make it through an approval, then we generate a plan for during construction. There's additional work to be done. There's more probes to be done. The report submitted by the geotech engineer has the traditional caveats on grouting and improving the areas under foundations. There was no evidence of a cavern or that would cause an immediate loss of the structure. These were in excess of 25 feet below grade, small 6 inches to 2 foot seams, and they were not continuous. So from a structural point of view, which is what I look at, they complied with the ordinance requirements, and the site is acceptable from the geotechnical point of view.
Can I ask some questions? Which ordinance sections did you just testify, in your opinion, were satisfied by the report?
And this is the one I usually look through, 243-48D.
Okay, can you read D?
All 60 pages?
Put it this way, doesn't D go towards what has to be in that report?
Yes.
What about A and B, which spells out what the board must find before it can grant approval? Specifically, doesn't D6A1 say that the board must find that the applicant has provided sufficient design and construction information to ensure that the proposed development of the track will not adversely impact on the health, safety, and welfare of the community?
Yeah, so in this review, we look through these, like the proof that the proposed method of development of the track will minimize adverse effects of quality from the geotechnical point of view.
No. Where's the sufficient design and construction information that the ordinance?
No sufficient design and construction. I've been providing square footage of the proposed structures.
Where's the design? They gave you a design, because it's not in the planning board file.
Why do I need a design of the actual building?
Because that's what the ordinance requires? I know that you haven't been doing it that way for 10 years, that's clear.
David,
But-
listen,
Yes?
I don't know you.
I don't know you either.
I know you started, and you may want to do that. I'll answer your questions, but the attitude, take it down. Sufficient design for a geotechnical report. They've told me the building square footages, and because it goes to, you asked me a question, let me answer.
I did, but A and B don't go to the...
Sufficient design, construction, and operational information that the development track will not adversely impact. From a geotech point of view, I'm looking to see if there's unique structures that could be impacted by a karst issue of a rapid settlement. They give me the building square footages, they give me the proposed bearing capacities, which the building code requires. They give me the seismic performance criteria based on the building code criteria for probes and borings. So for item number 1, from the planning board review, they need that.
So,
Geotechnical.
in your opinion, then, none of this stuff has to be on a final site plan drawing? No details of any of the structural foundation to deal with a sinkhole that might occur after construction? That's your opinion, correct?
If the board requests detail,
No, I'm not-
no, it's true. We've done this.
For 10 years, right.
We've had projects in the town where in the field, when stuff had gotten moved, we found a problem, and there was...
That's not the question. The question is, in your...
No, it goes to the remediation section of the code.
I'd like the witness to be able to answer
Yes.
this question. My friend John really keeps popping up and interrupting him. John, let the guy answer the question, then jump into the fray.
You're the board attorney here now, too?
I did it. You've been popping up and objecting, and you have a right to do it, and I have the same right.
Mr. Burns. He's right. My question was, in your opinion, is it your testimony that the ordinance that I just cited does not require any construction details on the final site plans before this board grants final site plan approval? That's my question. Final details
For what?
for design of the structure so that if the sinkhole occurs after construction, the structure won't fall in.
Then you're not acquainted with the process, but the building department will get the, no, hear me out, and let me answer. The building department, that's the process of this town. They submit building codes.
There's a written process like that, or is this just how you've been doing it?
We literally will get that plan, and before this gets, if it gets approved, you in the past have, part of your approvals, put in minimum requirements of additional work for every structure, every road, every utility. And that is anticipated to still happen here. The reason it's not as important now is because you may decide through this course of testimony that something moves on that site, or the building doesn't make sense where it is, it's too close to a property line. But our history has always been that there will be additional probing done. Even this dynamic report submitted for the project alludes to that, as well as Section 7, which is reevaluation, which basically says no matter what you agree on, if there's an issue coming in the field, that it will be fixed, stop work orders, that's Section 7.
If this was a preliminary site plan, I would wholeheartedly agree with you. It's a final site plan. they want to change it after the approval, they're going to need to get an amended final site plan approval. So again, I'm asking, I know that that's how you've done it. I know that that's how the planning board has done its resolutions. I'm fully aware of that. I'm asking you, is it your testimony and opinion that the way it's been done complies with that ordinance?
Right now, they do not have to do any more probes or borings. They meet the ordinance table.
I understand, they don't have to do any more bores, they don't have to do any more probes. In fact, I said last night when you weren't here, and I like this report, this is a great report. My beef is that none of the details are on these final site plan drawings. I'm asking a very simple question. In your opinion, I know how you've done it in the past, is the way you've done it in the past comply with that ordinance? That's my question, yes or no?
We never get building details.
I understand.
We never do.
I understand that, and that's how you've done it for 10 years.
But now the building code and the building subcode official have jurisdiction over those details.
Does that process that you've been doing here, which is obviously unwritten since you haven't said it's written, does that process comply with your ordinance section 243-48D, 6A and B? Yes or no?
From Geotech, I know that building can be built in that area. I say yes. I say
Yeah,
yes.
okay, he says yes, thank you.
Any further questions?
You know I believe no.
Fair enough. You're entitled.
All right, at this point, you want to put your next witness on? Okay. This gentleman will not yet. Please sit down.
In your opinion, sir, that have the studies that have been presented to you comply with the requirements of Lopatcong?
Yes.
And you started to give the procedure, and then Mr. Drill interrupted you. Do you want to give the procedure that occurs in this municipality?
No, I mean, it's just a fact of the process. Things could change even during a final plan where they've written the report ahead of time. You move things around, and even if you don't, we still make recommendations as part of final conditions. Like I said, I don't think there's been an application through here that did not have probing or additional testing as part of a standard development, I guess, a final approval from this board.
And
whether that is written down, maybe it should be formalized, but it just depends on the nature of the way the board.
And when you review applications, you consider the location of the structures on the site.
Oh, yes, we see where they first are. That's the reason for the soils report. Maybe we have in the past recommended maybe possibly moving certain structures, be it residences, not, because it made sense with what we discovered in the reading the probe data. We have. In this site, there's no reason to move anything.
So you in fact have studied the site, you've studied the applicant's report, and you considered the location and type of structures in making your review.
Yes, from a geotechnical point of view, this is the building.
That's part of the review, right?
That is my detailed scope
Yeah.
of work.
And as far as the details of construction, after you've done it, the details are subject to the building code and the building inspector, correct?
And in conjunction with whatever is written in the ordinance, I mean, the approval, I keep getting it wrong, the final approval, the resolution of approval, and this town has historically always required geotech considerations during construction. In fact, the section 7 of the ordinance addresses for field conditions that may occur.
Thank you.
One last question. So I take it that in your opinion, if the board grants approval to an application that has geotech issues and has a very good geotech report like this, but with no details on the plan, subject to you basically delegating you the authority after the approval, in your opinion, that satisfies the ordinance of the board finding there's no detrimental impact by delegating you the authority to find no detrimental impact, correct?
No, it's someone during construction. It's usually the contractor. We put in minimum testing requirements. They're required to contact us to observe that work.
So when do the details come in, for example, when do the details get placed on construction drawings for how a foundation is going to span a potential sinkhole?
No, the soils report is, in their report, they're grouting it. So they plan on grouting their foundation.
Well, I understand that that's what it recommends. There's nothing like that shown on the plans, but I'm saying that, are you saying that if they do a pre-grouting program, that you're not going to require that there either be grade beams or some foundation design that can span a 10-foot open sinkhole, that if they grout it, that's it and they're done?
They're grouting the full area, which they indicated they were going to do. The answer would be no.
And ask you again, so in your opinion, routing it without doing any modifications or anything to the foundation to span a potential sinkhole is satisfactory.
Because the boring showed 25 to 40 feet before I even get the competent rock.
So
So there's
again,
plenty of soil over it. The answer to your question is they're proposing grouting in limited areas, but under every structure. They're not grouting the parking lot. They're not grouting the driveway. But they are grouting the proposed structures. Because like,
so your recommendation, your professional
yes,
recommendation
the 10-foot
to the
span,
firm.
the 10-foot span that you're talking about was a recommendation that started almost 25 years ago before they really did do a lot of grouting. The 10-foot span of holding a corner, if a 10-foot hole opened up under it, was literally from 1978. But if you're grouting the whole thing, then the concern of the sinkhole goes away. And they have proposed grouting,
So,
which is like pine.
okay, so you're now saying that that old specification, the 10-year-old specification for the 10-foot span is outdated.
No, we allow it, we want it when they're not going to grout the whole foundation,
But if they grout it, they don't have to do it.
because they're replacing all the chances.
Are
of
you
holes.
aware that that's one of the general recommendations in the appendix to here is to do the 10-foot span?
We use it if they're not grouting, because the technologies don't exist.
But
You're right, it's in there.
Right.
We can
Thank you.
deviate from it as well.
Thank you.
That's why they call them building codes.
Mr. Major? Do you have any further witnesses or questions?
Yeah, which do you consider superior, the span or the grouting?
Oh, we would always prefer the grouting, because your chances of, you're improving the soil infinitely better.
Right?
Louis Cardona, 1119 Fifth Avenue Alpha. This is Serpentine, right?
Yes.
Louis. You mentioned probing and boring,
Yes.
and you mentioned 25-foot depths. Which one goes to 25 depths?
Oh, no. The test borings there's 3 test borings. They met the criteria for number, and they went at least 20 feet into rock, or 50 feet deep. That was the requirement for borings. The test probes varied in depth, some up to 50, some 35. They varied, the probes varied. The test borings met or were done to meet the 20-foot rock requirement, which they did with the exception of one where they hit the 50-foot depth cutoff before they got to the full 20 feet of rock.
With the actual testing that you saw and the depths that they've reached, is it possible there are caverns below that depth?
It's very possible.
Thank you.
Mr. Major,
Question, Mark Lilac.
state your name, please.
I wanted to ask Mr. Serpico, as president of Overlook, did you do the boring?
Please state your name.
Mark Lilac, I'm the president of the Homeowners Association of Overlook,
And what's your address?
125 Marlborough Circle. Since I've been president, and since Overlook has been established, and the planning board has come, that we've had over 20 sinkholes.
I don't know where that is. Where is it?
That's right in the packet. Plus, we've had all.
No, I mean, Paul will have a comment.
Yeah, that's what that's what we're having a problem. As a matter of fact, Paul's got about for drainage issues that we're having. Now, I think it's coming out next week. I was just concerned about, how far and how extensive the drilling is. Like you say, it goes down 25 to 50 feet.
That's required in the thing, is to go in.
And you say that you did find fissures that were approximately what depth, would you say?
They were greater than 25 feet.
50.
I think there was one at 17 to 18 feet.
Okay, I just want to be aware.
No, but in fairness, a lot of the reason I don't know the names of the projects, because usually they're unnamed by the time I see the reports.
Yeah, I just
They're
know there's a whole host of
I
problems.
guess I haven't heard anything about them.
And I was concerned because,
We do probably.
yeah, I would think the planning board, probably was not this planning board, but there have been mistakes done, and we've been through a plethora of problems, millions and millions of dollars that we've spent. Because the planning board approved certain things that Cedar Morrell,
In fairness, though.
the builder had done. which
In
is very-
fairness, though, some areas, the whole idea of the cars, there are certain areas, and there's been a lot more work. I've been doing it, and you see those, and you find areas that are worse. So we are sensitive. That's one of the reasons we always ask for more probes, even though they're not written in the ordinance. So you do learn from.
Yes, sure, and as he had testified earlier, in regard to the drainage issue and the overflow issues, we've had problems, extensive problems there also.
Yeah.
And there's nothing we can do about that. And it was approved by the planning board, they said everything was all right. Again, it's gonna cost us thousands of dollars. They don't foresee these problems. What I'm just saying is that we would just like and appreciate that the planning board take as much, take a really hard look at what you're doing here before you make a decision.
Thank you, Mr. Chairman. At this point, we'd like to call our next witness, Kevin O'Brien.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
State your name for the record and spell your last name.
My name is Kevin O'Brien, O-B-R-I-E-N.
Thank you. Mr. O'Brien, if you would, for the board, would you please describe your qualifications, education, and experience as a professional planner?
I am licensed by the state of New Jersey as a professional planner. I am certified by the American Institute of Certified Planners. I am a member of the American Planning Association and the Institute of Transportation Engineers. I have a graduate degree from the New Jersey Institute of Technology. I've worked for about a dozen municipalities in northern and central New Jersey, and I've appeared before over 200 zoning and planning boards throughout the state. I've also testified before the New Jersey State Legislature. I've been retained as a subject matter expert by the New Jersey Board of Professional Planners, and I've appeared in Superior Court in Camden, Morris, and Hudson counties.
Were you previously accepted as an expert in the field of professional planning before this board?
Yes, I was.
Mr. Chairman, with that, I'd like to move to qualify Mr. O'Brien as an expert in the field of professional planning.
Without objection, we will so qualify him.
Thank you very much. Mr. O'Brien, you've heard the previous witnesses testify about this application, correct?
Yes.
And are you yourself familiar with the application?
Yes.
Turning first to the site plan component of the application, is it correct that the application seeks site plan approval for a conditionally permitted use in the township's ROM zone?
Yes.
And does the application as presented meet the conditional use standards set forth in the Lopatcong Township zoning ordinance?
Yes.
Can you describe for the members of the board and the public the area that surrounds the subject property? I think you're going to refer now to Exhibit A1.
Yes, I am. The board is familiar with the site of the proposed facility, which is in the interior of the lot, behind the manufacturing facility and beside the cement plant and behind the self-storage area. Across the street is the plastic manufacturing plant. There's also a truck terminal in the vicinity, and across the top here is Route 57. The precast concrete is right next door, and the truck transfer is also adjacent to the proposed location, and across the street is the plastics manufacturing facility. The area south of Route 57 and west of Strikers Road, as well as east of Route 22, is commercial and industrial in nature.
Does the use as proposed, Mr. O'Brien, meet any of the goals and objectives of the New Jersey Municipal Land Use Law?
Yes, it does. The municipal land use law sets a number of goals for planning and zoning. In New Jersey statutes annotated 40:55D-2, the purposes of zoning are listed. And among those purposes are the following: A for alpha, to encourage municipal action to guide the appropriate use or development of all lands in the state in a manner which will promote the public health, safety, morals, and general welfare. Item G for golf, to provide sufficient space in appropriate locations for a variety of commercial and industrial uses according to their respective environmental requirements in order to meet the needs of all New Jersey citizens. Item I for India, to promote a desirable visual environment through creative development techniques and good civic design and arrangement. And finally, item M for Mike, to encourage coordination of various public and private procedures and activities shaping land development with a view of lessening the cost of such development and to the more efficient use of the land. And I believe that the application meets these goals by providing both permanent and temporary jobs and a tax rateable for the township, which advance the general welfare. It provides space for commercial use in a zone that is zoned for this commercial use and is compatible with surrounding uses. It promotes a desirable visual environment by locating an industrial facility well along the Strikers Road in the interior of a block and out of the usual line of sight of passers-by. The use is allowed in the zone. This lessens the cost of development and coordinates public and private procedures.
Mr. O'Brien, have you reviewed the Lopatcong Township Master Plan?
Yes, I have.
Is there anything in that master plan which would speak to this application?
Yes, there are a number of entries concerning this in the 2005 Master Plan Reexamination. On page 2, under land use, item 3 states, quote, promote design layouts which utilize road capacities of arterial and collector roads, encourage through traffic to use these designated roads, and discourage through traffic on local roads. Item 4, encourage the integrated development of the industrial district south of Route 57 to ensure adequate services and accessibility. Item 5, encourage flexible development techniques which will minimize disturbance of sensitive areas and incorporate natural features into the project design. And this application accomplishes those goals by using collector roads to access the site and county or federal highways, not local roads. The proposed site is in the midst of other industrial uses south of Route 57 and is allowed as a conditional use in this zone. The use of flexible development techniques, such as the use of a private instead of a public road on this site, saves maintenance work on the part of the township. Development of this industrial use on an interior flyby minimizes the impact by placing it behind other industrial uses. On page 4 of the Master Plan Reexamination, under Economic Development, the Master Plan states under item 1, quote, promote land uses which will provide a favorable fiscal balance and stable tax base. Item 2, encourage development of local employment opportunities within the township. Item 4, revitalize the Route 22 corridor to capitalize on the change in function and traffic flows after the opening of Interstate 78. And this accomplishes those goals by enlarging the tax base with an industrial rateable, which has no residential component and a positive fiscal impact upon property taxes. The applicant will create over 100 construction jobs during development and over a dozen permanent jobs at this site on a regular basis to be filled by people from this area. The applicant will primarily use Route 22 for site access. Thank you.
Mr. O'Brien, again, with regard to the site plan and conditional use component of this application, does the application as presented require any variance relief?
No, it does not.
We turn now to the subdivision component of the application. Do you agree that the application is a conforming application with the exception of the fact that it lacks frontage on an improved public street?
Yes, I do.
Is it correct that the variances being sought are planning variances necessitated because the applicant seeks to create two lots that do not have frontage on an improved public street?
That is correct.
Does the subdivision as proposed meet any of the stated goals of the New Jersey municipal land use law?
Yes, it does. And I would reiterate the goals that I stated a moment ago. Goals A, Alpha, G, Golf, I, India, and M, Mike, also apply for the same reasons.
Is there anything in the Lopatcong Township Master Plan which would speak to the application for subdivision presented here this evening?
Yes, and similarly, the re-examination under page 2, items 3, 4, and 5, page 4, items 1, 2, and 4, would similarly apply for the same reasons to the subdivision application.
Mr. O'Brien, how are the variances that are requested by the applicant justified?
Under the municipal land use, section 35, concerning access of improved lots to a public street, that discusses emergency access maintained to public standards. The access road will be improved to public standards, as has been testified to by both the applicant's engineer and the township engineer. Because the interior lot will have no street frontage, it will have access through that private road, which has been built to township specifications. However, the township will not have to maintain that road as in paving it, maintaining it, cleaning it, or plowing it. The township benefits by the applicant providing a private rather than a public road.
And can the variances requested by the applicant be granted without substantial detriment to the public good and without substantial impairment of the zone plan and zoning ordinance?
Yes.
In closing, Mr. O'Brien, given that you have testified that the use proposed is a permitted conditional use which meets the conditions of that conditional permitted use, that the subdivision is conforming, and that planning variances for lack of frontage on a public street will be a benefit to the community and could be granted without any detriment, have you reached a conclusion pertaining to the application as presented?
Yes, I have. This applicant is for a conditionally permitted use. It is surrounded by similar industrial properties. It conforms to the master plan by providing a new development that provides jobs and ratables with a positive fiscal impact on the community. It is particularly suited for this location because the development is compatible with surrounding uses and meets all requirements of the township. This application satisfies the negative criteria and that it will have no substantial negative impact upon surrounding properties, all of which are industrial in nature, as has been testified to previously. Now, I conclude that this application can be granted without substantial detriment to the public good and without substantial impairment of the zone plan and the zoning ordinance.
Nothing further on direct at this time, Mr. Chairman.
Just have a couple of cross-examination questions.
Okay, after that, I just want to tell the audience I'm going to take a break for the court reporter.
What variance did you say was required for this application?
Municipal land use law, section 35.
Okay. What's the standard to grant a variance from MLUL section 35?
Let me get my book.
It's on page 1167. Bottom of the page. Okay, the question was, in case you forgot,
I just want to get the actual quote from Mr. Drew.
you can read it. You can read the book.
I will. final sentence. Under section 36 of the municipal land use law, it says, I'll paraphrase just a little bit, for the enforcement of section 35 would entail practical difficulty or unnecessary hardship, or where the circumstances of the case do not require the building or structure to be related to the street. The Board of Adjustment may, upon application or appeal, direct the issuance of a permit subject to conditions that will provide adequate access for firefighting equipment, ambulances, and other emergency vehicles necessary for the protection of health and safety, and that will protect any future street layout shown on the official map or on a general circulation plan elements for the municipal master plan.
Now, without having to read any further, I will agree that the planning board can grant this variance in this particular case. You don't have to worry about that.
Right.
First question, are you contending that there's any practical difficulty here, and is that the basis for the variance request?
What I'm contending is
No,
that...
I know. I'm asking you, are you contending there's practical difficulty? I didn't ask you what you are contending. I'm asking, are you contending that there's practical difficulty? That's a yes or no question.
There is practical difficulty based upon the size and shape of the lot.
What's the practical difficulty with making that a public road instead of a private road? It would be the same size, wouldn't it?
There is no practical difficulty in making this a public road.
So you're not contending that there's practical difficulty for the basis of the variance, correct?
I'm saying that there is practical difficulty for this street based upon the size and shape of the lot, that this provides the only access to this lot. And whether it's going to be a private street or a public street is up to the municipality. The applicant has agreed with the township to make it a private or public lot, street, depending upon the municipality's wishes.
So the applicant...
And the applicant is offering to maintain it as a private street that has been approved to public standards.
If the applicant offered it up as a public street, you would need a section 36 variance, would you?
That is correct.
So again, I'm asking you, what is, if you can make it a public street, but you prefer to make it a private street, what practical difficulty is there making it a public street? I understand what you're saying, it's going to save them money. I understand. Saving them money is not practical difficulty for your client, correct?
It's a practical benefit to the township.
But it's not a practical difficulty to the applicant, correct?
There is no difficulty to the applicant in providing a private or a public street.
Right. That's what I was getting at.
Municipality. However, the access to the lot itself is designated by the size and shape of the land and the fact that this is a flag lot.
Right, again, I mean, we can go round and round all night, but if it's a public road, you don't need a variance, correct?
Agreed.
Right, so again, are you not going to concede that there's no practical difficulty in that you can make this a public road if you wanted to? Or are you going to contend that, yeah, there's some practical difficulty, you can't make it a public road?
Mr. Bryan, can I jump in here? The practical difficulty is that I was not going to approve the plan if that road is a private road.
And why is that?
Why?
Yeah.
Because I didn't want it to be a public road serving two lots where the township was going to have to pick up and incur the maintenance and the capital repair costs. So I discussed this at length with the applicant when we were conceiving this job. I told them I wanted this as a private road. And they ultimately agreed to do that, and that's why this plan is here tonight in the form that it's at and why the planning variance is being created.
Oh, I understand why you want it, Mr. Sturbins. What I'm asking is, there has to be a legal reason to grant it. Because it's going to save the township money, does not fit practical difficulty. I'll go to the next one. Is there an unnecessary hardship that you can't make this as a public road, or is it just because you want to save the township money? If you just want to save the money, say it.
The unnecessary hardship is to the township.
There's no unnecessary hardship to the applicant, correct?
No, the applicant is perfectly content to do this either way that the township wishes.
So, is the standard thing you're using a C2 variance standard, where the benefits outweigh the detriments, because somehow you're going to save the money?
The benefits of this application do outweigh the detriments in terms of the street access, because it does save the township money, and it is a better planning alternative to the public street, excuse me.
Right, but the C2 variance standard doesn't apply to a section 36 variance, does it? Read the language again.
Not explicitly, no.
Oh,
It is a
okay.
better planning alternative. That is one of the considerations that this board will review in the course of its deliberations.
So you contend that it's not explicit, so it's implicit that you can use C2 variance grounds to get a section 36 variance? Is that your testimony?
I don't think that you have to explicitly say that a planning alternative, that a better planning alternative outweighs the detriments, specifically only applies to a C2 variance, but can be applied in many ways throughout the municipal land use law.
Now, how many lots are they proposing, 2 or 3?
Sure.
Which lot does the private road easement pass over? If you want to ask that, go ahead. I have no problem with that.
Let the
Yes,
civil engineer.
you go ahead.
Mr. Smith?
You can even whisper in his ear. I'm not going to...
I'll let him answer the question.
It doesn't pass over either of those lots.
It's a separate lot.
It is a street, it's a private street.
Is it a lot
It's
or
a
not?
it's a private street.
Okay, so are both of your contentions that by creating this private street, you're not creating a third lot here? It's only a 2-lot subdivision, but there's a private street that has its own lot number?
Just two building lots.
2 building lots. Isn't there 2 building lots and 1 private street lot?
There's a private street.
Is it going to have a separate lot number?
By not filing law, the township will need to assign it a lot number at the time that the final plat is filed.
Okay, so Mr. O'Brien, is it your opinion and testimony that you can have a 2-lot subdivision and create 3 lots? Wait, don't you need a 3-lot subdivision to create the private street?
This is a 2-lot subdivision in front of this board.
Okay. No more questions.
This time we'll take a 5-minute break and we'll allow the board to reload the meeting.